Hello guys, this is Steno for All YouTube channel. Here we provide you Hindi or English shorthand dictations at different speed. Today I am going to provide you English dictation at which will help you in various steno skill tests. Get ready for 120 word per minute shorthand dictation. Prime Minister Modi last week elaborately pitched India as an investment destination that could serve as a manufacturing hub at the heart of global supply chains. The pitch made at the US Strategic Partnership Forum comes in the backdrop of the government's keenness to use the disruptions the COVID 19 pandemic has caused to the cross border movement of goods as an opportunity to lure potential investors, especially those looking to relocate from China to India. This tact is consistent with recent initiatives to explore supply chain synergies with other economies, including Japan, as an escalating border feud casts a shadow over India's economic and trade ties with its northern neighbor. The reasoning appears to be that if even a few multinational enterprises can be drawn to set up manufacturing bases either by shifting facilities or as new additional plants, then not only does the Indian economy stand to gain FDI, new jobs, and tax revenue, but it also makes a statement. Clearly, officials must have advised Mr. Modi that US businesses were the ideal target given the worsening relationship between Washington and Beijing and the ongoing trade standoff between the world's two largest economies. On the face of it, the approach seems inarguably sound. The rub, however, lies in the government's recent Atmanirbhar Bharat initiative of making India more self reliant. Over the decades, it has been established that global FDI investors priorities and are even willing to pay a premium for policy stability and largely barrier free access to local and international markets. The drive for self reliance has spurred several ministries to urge companies and industry sectors to replace imports with made in India substitutes. From the shipping ministry's call for the design and manufacture of indigenous tugboats to auto component makers being told to abjure foreign parts, the thrust of the initiative is evidently import substitution. It is hard to imagine any potential foreign investor in manufacturing being ready to source capital goods locally, assuming they are available even at the cost of possibly compromising on quality or price or both. Betraying the government's anxiety, Mr. Modi took pains to stress that the push for self reliance should not be interpreted as India turning its back on the world. Separately from the market access perspective, India's decision to not join the RCEP multilateral trade pact would not investor companies seeking to tap consumers in RCEP member countries at a tariff disadvantage. Interestingly, most of the recent FDI announcements have been by way of stake acquisitions in existing businesses and predominantly in the services sector. Attracting FDI into manufacturing will require the government to convince investors that it is committed not merely in words but in deeds as well to an open barrier free global trade and investment order. This past fortnight has seen two significant developments in connection with the Indian judiciary. The first was the decision of the Supreme Court of India in the matter of Prashant Bhushan's contempt case, and the second was the retirement of Justice Arun Mishra. These events, in their own way, magnify the chinks in the armor of the Supreme Court. The Bhushan case. In the first instance, the Supreme Court, in a display of self-proclaimed magnanimity, let off Mr. Bhushan with a fine of 1 rupee in the contempt case against him over 2 tweets. In the alternative, the top court ordered for a 3-month imprisonment term and 3 years debarment from practice. The court chastised him for his conduct, which, according to the court, reflects adamance and ego, which has no place to exist in the system of administration of justice and in noble profession, and no remorse is shown for the harm done to the institution to which he belongs. It would be trite to say that these words ring hollow coming from a court that chose to relentlessly pursue Mr. Bhushan in a petty exhibition of arrogance itself. Over the course of the hearing, the court repeatedly tried to coerce the contemner, that is, Mr. Bhushan, to proffer an apology and kept granting him additional time, a few days, a few hours, etc., for this purpose. It was arguably strange behavior on the part of the court, and it also appeared embarrassing, for it came across as petulant bargaining more than anything else. Mr. Bhushan, with appropriate decorum and honesty, admitted that any apology from him in the circumstances would be insincere. The jurisprudential contribution of this decision to the law of contempt will be studied for years to come, surely, but maybe not for the reasons that the court intended. Hopefully, a wiser judicial and legislative community will realize one day how utterly self-defeating this law is for a healthy democracy and eventually change the law around. A judge in the timelight. This was among Justice Mishra's last few decisions as a member of the Supreme Court before he retired on September 2nd. As a result, considerable attention has been paid to his decisions during his tenure, which lasted from 2014 to 2020. One consistent feature has revealed itself throughout, which is the kinds of cases that were assigned to the benches he was on and the kinds of decisions he issued. In the judge's press conference 2 years ago, the primary grouse was with the master of the roster system and the specific concern that politically sensitive cases, that is, dealing with the executive, were being allocated to benches involving Justice Arun Mishra. Even if not mentioned by name, his role was clearly insinuated, notably with reference to the Judge Loya case. Commentators, for example, Aparna Chandra, Anup Surendranath, V. Venkatesan, have also conducted detailed analysis of Justice Arun Mishra's decisions, and studies have found that these were predictably in favor of the executive. In recent times, many columnists, leading scholars, and legal luminaries have speculated on the marked drift of the Supreme Court away from rights-based court to an executive court. Of course, to keep such a court going, a judge who is ever ready to step up to handle politically sensitive matters and who can be relied upon to issue decisions that are in favor of the executive is always useful. However, even as the limelight is on a judge such as Justice Mishra, in circumstances like this, the role of the Office of the Chief Justice of India (CJI) in facilitating the creation of an executive court cannot be ignored. The allegations and suspicions have been voiced from within as well, with Justice Kurian Joseph suggesting that the assignment of work in the court during Justice Deepak Mishra's tenure was remote controlled. During his time, 2 judgments were delivered by the CJI's bench in matters to which he himself was a party. Through these judgments, the CJI defended the master of the roster system, indicating that the CJI was entitled to have unrestricted and untrammeled power in matters of case allocation. After the press conference, one hoped there would be rethinking on this, but nothing has really happened and things have continued in the same way since. The master of the roster system was designed for a different era and indeed may have worked well in the past even when we had very tall judges and judicial independence was rarely doubted. But things have changed now. Recall that the